Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes, can I get the case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right.
241388 SM.
241, what else?
38 SM.
38
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see, January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
Right, so I would like to talk to him right about how the case should be dismissed based on.
As the defendant approaches, the judge allows him to choose between standing at the podium or remaining seated. While that may seem trivial, it's actually a subtle act of judicial control. Giving a defendant a small choice early on helps reduce tension. It communicates fairness, but within firm boundaries. Experienced judges often use this to maintain authority while showing balance.
A matter of People versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, want to put your appearance on record?
Hey, good morning, Your Honor. Or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed. I'm consenting to any of these proceedings, you know. I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackleford, who did not give me a personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date. She'll send you a notification of the date for the jury trial. In the meantime, I'm going to continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
The dialogue begins, and the defendant's tone immediately raises questions. There's hesitation, deflection, and a noticeable discomfort. Judges are trained to pick up on nonverbal cues, shifts in posture, eye contact, pauses before answering. These moments often tell the real story long before the words do. It's not confrontation yet, but we can see it forming beneath the surface.
You
I have-
file that motion in writing and I'll take a look at it.
I already
In the
did follow with the,
in the meantime, I want you to go with the sheriff and he's gonna take care of you.
hold on, object, I have some, I already
Put 'em
filed it with
on,
the
put 'em on
I'm
mute.
making that motion now. I'm making that demand actually now, because it's a constitutional right to be
Denied,
presented without guilty.
denied.
All right, then I'll be taking your job. How about that? Because you violate my constitutional right, and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold their office. But don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out.
The defendant begins challenging procedural aspects, possibly questioning charges, timing, or representation. This is a common defensive mechanism. When the facts are unfavorable, some defendants redirect the focus to perceived unfairness. The judge, however, remains composed. This composure isn't weakness, it's strategy. Maintaining calmness is a way to avoid escalating resistance while reinforcing judicial authority.
People of the City of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel.
Yes, due to, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. And I don't due to canon law being, unfair. It's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial, is that right?
Yeah, but I wanted jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury.
That it is a jury of your peers. So, and I'll determine that. So we will have this set and then I'll mail out the date for the jury trial.
I believe is a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections. I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond.
Here, the defendant invokes legal rights, some valid, some misinterpreted. Judges must navigate these moments carefully. Over-explaining can appear defensive, while ignoring false claims can seem dismissive. So, judges tend to recenter the discussion on record-based facts, the charges, previous conduct, and procedural law. It's a balancing act between education and enforcement.
Even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here,
So you're in there for a different matter because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. Well, I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date? With whatever you're doing there.
There is no out date. That's the thing. It's so is this about the moped case?
Yeah, this is driving while
Okay,
your license is suspended.
I wasn't sure, right? They got me legally confined right now in the domestic violence, no evidence at all. She lied, made a statement, so now they
Well,
got.
hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. So I suggest like not bringing up the other case. This case here is on the moped and the driving on a suspended license, or revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, you want to call it this, the remote Zoom thing away from the door before I could read to hear. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1.
The courtroom tension builds. The defendant's arguments begin blending legal terms with emotional reasoning, a hallmark of self-representation. Without trained counsel, defendants often overestimate their understanding of law, using legal jargon as armor. The judge's patience here is commendable. Maintaining civility while the legal process is being misused requires discipline and restraint.
That's my house. I'm allowed there. You
Well,
ordered
these
that,
other
it's illegal. That violates my due process.
All right, he has a $2,000 cash bond with a GPS tether.
Yes,
And he's not to
that violates my right to a
return.
personal bond.
He's
I have a
not
constitutional right
to
use it.
appear at
He's
9.
innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So,
All right. So what I'll do is, I don't know when that case is next. The next day, is that it's a state case? Ms. Van Reno, you don't have that case, right?
I don't
so
know
it must
anything
be a
about
state.
that.
All right. And so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But let's get a date.
I won't touch up. I was going to object before you guys don't give me a chance to talk. I object to it should be. I moved that to be stayed. This moped case till I get out of prison. I mean, till I get out of jail here. I can prepare myself. I can probably prepare myself.
Right, that's right. Listen.
Ask to my legal authorities to argue nothing.
It's being set for a jury trial.
The other one is?
From yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm going to set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, I mean, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as the date right now, I just want to put a date on the books so that we know that you have an idea. I mean, if you get out tomorrow, then you'll know and what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
So
I'm sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, it's only a couple of weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple of weeks to, I mean, it's a driving on a restricted license. So it's not exactly a whole lot of prep time for that. It's not a homicide.
By this point, the judge starts subtly tightening control. Notice how he interrupts less, speaks slower, and waits longer before responding. These are communication tactics designed to de-escalate. In high-tension hearings, silence becomes a judicial tool. It allows defendants to reflect, or in some cases, expose their own inconsistencies without direct confrontation.
Where I'm at with things. So we're going to set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's the more I want to say to, okay, with the prosecutors here. Dealing with this other case that I'm here for now, I request that.
Not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case, so that's a Wayne County Prosecutor's Office.
No, so
not the city attorney.
I'm talking about the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now, and also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charge against me, but they don't have no evidence. I do. And I should be the one suffering here in jail as a lack of evidence as a result of the unequal protection clause.
And that's on your other case, sir. So
it's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, that's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay? That's why you have a good rest of your day to you and your staff.
Thank you, Your Honor.
I have ever seen someone age an entire decade over just 3 weeks.
McMullen, case, the motion to set aside. Let me bring them out. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under Canon Law 3228 that, you know, that say otherwise, and there's a lot of support what I'm saying. So that's why I say what I say to, you know, for the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th.
As the hearing nears its close, the judge outlines the next steps: trial dates, conditions, or compliance requirements. Notice the tone: measured, not emotional. This closing structure is essential. It ensures no ambiguity remains, preventing future claims of misunderstanding. Every hearing ends with clarity, even when emotions run high.
And also, go ahead and also want to say, I ask that you give me all the time to speak, say anything I want to say, you know, instead of like shutting the court proceedings off that's happened before. Make sure I'm done with everything I have to say. But that's it for right now. But like I said, I might have to say depending on what you say in response. So.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing. It's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. So.
I'm just asking the reason, I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
you'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still.
Before adjourning, the judge gives a brief but impactful statement, one that reaffirms the importance of accountability. It's not about punishment alone. It's about restoration. For many viewers, this is where justice feels most human, firm consequences paired with an opportunity for growth.
Jurisdiction of this court. So you live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet. I have more to say.
Number 235256.
Sierra Coke on behalf of the people.
Thank you. Mr. Kuhn is present here in the courtroom today. This was originally set as a sentencing hearing. Mr. Kuhn, I got a report from the probation department indicating that you declined to participate in the investigation process.
Up here. Greetings, Your Honor. I'm here by special appearance, not a general appearance, and I reserve all my rights and explicit reservation without prejudice. I, Paul Kuhn, a sentinel moral being, have examined the path of my feet on and have concluded that I have dishonored many people, including, but not limited to, the people, the peace officers, the city, the county, and to determine that I have made many mistakes, and I'm sorry for my sins, and therefore I repent now. I have become aware of other sins I may have committed. It has come to my attention that you have never informed me of my choice of law. And to make matters worse, you chose an inferior form to have me tried under. You are either incompetent or collusive with the prosecutor. Either way, you have provided me with ineffective assistance of counsel, which has caused me great harm.
You were fired. Okay. Do you intend to hire another attorney? Are you appointed?
I was appointed.
How are you going to proceed in terms of counsel, Mr. Kuhn?
Oh, I'm going to do it myself.
Okay. All right. You understand that you have the right to have an attorney?
I do.
And you understand that if you can't afford an attorney, you have the right to have one appointed for you at public expense. And in fact, that's what we've been operating under up till now.
I have gotten legal counsel, but anyways, I'll accept whatever you have.
Okay, so you understand that you do have the right to have an appointed attorney if you can't afford one?
I had him, and he has done me no good from the beginning. So
yep.
At this point, I'll just I'll take whatever you got to give me.
And that concludes today's hearing. What stands out most isn't the confrontation, but the composure. The judge's discipline, the legal clarity, and the balance between authority and fairness all reflect what the judicial process should embody. For those watching, It's a reminder that justice is often quiet. It doesn't always roar, but it always stands. If you found this breakdown insightful, don't forget to like, subscribe, and share. Join us next time as we analyze another real courtroom moment with professionalism and perspective.